Hello, dear students. I am Ömer Ali Girgin. I am a research assistant in Anadolu University Faculty of Law, and my department is Civil Law. Today, we are going to have a look at the Introduction to Law book and Chapter 3, Introduction to Human Rights Law. In this chapter, we will see concept and definition of human rights, international human rights standards, and procedures and institutions for protection and promoting human rights. Okay, if you are ready, we will begin with the human rights definition. Human rights are about dignity of the human. This is a very basic, very simple definition. Of course, there are a lot of definitions in the doctrine, in the books, but we will only say this basic definition for now. Human rights have some characteristics. Okay, what are these characteristics? Human rights are universal. Human rights are equal. Human rights are indivisible. Human rights are inalienable. So, human rights are universal. That means it's global. It's for everyone in the world. And human rights are equal. That means it's applied to all humankind equally. They are indivisible, it's clear, and inalienable. That means you cannot sacrifice that. You cannot give it to another person. It's yours. Okay, let's continue with the fight between people and the kings, monarchies about the human rights to get the human rights. Okay. The existence of human rights is a result of struggle against unrestricted absolute power of rules. In that sense, early examples of documents limiting absolute power in a constitutional status are Magna Carta, Petition of Rights, the American Declaration of Independence, the French Declaration of Human and Citizen Rights. The last one, is the most important one, the French Revolution. Okay, let's continue. International human rights standards. What can we say about this? The principle to respect human rights is established by the Charter of the United Nations. The General Assembly of the United Nations adopted the Universal Declaration of Human Rights on December 10th, 1948. It sets common standards of achievements for all individuals and nations. In order to codify human rights standards in legally binding conventions, some steps were taken by the United Nations. As a result, several conventions have been adopted to safeguard human rights in different areas of life. Okay, we can understand under the United Nations, human rights are protected. So, what's the beginning? We can say the 1966 we have two conventions. These are very important, and these are called twin conventions. Okay, let's see what are these conventions about. The International Covenant on Civil and Political Rights, 1966, as we said before, protection against abuses of power. The International Covenant on Economic, Social, and Cultural Rights, 1966, as we said before, enable individuals to live a decent life and fulfill their essential needs. Okay, so we saw these twin conventions about. Under the United Nations, protection of the human rights are not the only one. There are some regional steps. There were some regional steps too. So the European Convention for the Protection of Human Rights and Fundamental Freedoms in 1950, the American Convention on Human Rights, the African Charter on Human and People's Rights, 1981. The Inter-American Convention. These are only examples. There are many of them in different dates. As you see, we can say that these are the regional, not global, but regional. It only considers about particular country or continental or state, we can say, or geographic area. Okay, in order to monitor respect for human rights in the member states of the Council of Europe, the European Court of Human Rights was established. This is a very important issue because the Turkey is a member state of the Council of Europe. So the European Court of Human Rights is very important to Turkey. Okay, while monitoring, the European Court of Human Rights interprets the provisions of the European Convention on Human Rights by its case law, which in turn results in keeping the European Convention of Human Rights a living instrument. The scope of the jurisdiction of the European Court of Human Rights covers violations of the European Convention on Human Rights, brought as individual applications or interstate applications. So there are two kinds of applications to the court, European Court of Human Rights. First one of them is individual application. An individual can apply to the court and complain about his or her state. Or interstate applications, that means one state complains about another state. Of course, they have to be member states of the European Council. Human rights under Turkish legal system. Under Turkish Constitution 1982, human rights are articulated as fundamental rights and freedoms. It's stated in the preamble of the Constitution that every Turkish citizen has the right to the fundamental rights and freedoms laid down in the Constitution in accordance with equality and social justice, to lead an honorable life and improve his or her material and spiritual well-being under the aegis of national culture, civilization, and the rule of law. Human rights are protected under the Constitution in Turkish legal system, and the individual application has been introduced into the Turkish legal system by the constitutional amendment made on 2010 with the law now 5982. After this amendment, Turkish citizens can apply like themselves, individual application that they can make to the Turkish Constitutional Court. This instrument about protection human rights, there was no individual application before the 2010. So after 2010, Turkish citizens can apply individually to the court about violations their human rights. By this amendment, the individual application was enshrined the Article 148 of the Constitution. Okay. The last heading of our chapter of our book about some selected cases of the European Court of Human Rights on applications from Turkey. Okay, on this event, on this decision, there is a applicant, Ayten Unal, was a Turkish national and lawyer. She started her professional career and made business network with her maiden name. She couldn't use her maiden name at official documents after her marriage. The case she filed at national courts rejected on the basis of Article 153 of the Civil Code, which prescribed that married women must use her husband's surname after getting married. Referred article amended afterwards, and married women acquired the right to use her maiden name beside her husband's surname. However, the applicant preferred to use her surname merely. So, court's decision, court didn't found justification for different treatment for Ayten Ünal. And case of Cumhuriyet Vakfı and others versus Turkey. Applicants İlhan Selçuk, Güray Tekin Öz, Joint Stock Company, Yeni Gün Haber Ajansı Basın ve Yayıncılık and Cumhuriyet Vakfı are respectively Chief Editorial Writer, Editor-in-Chief, Publisher and owner of the Cumhuriyet newspaper. In the course of presidential election, Cumhuriyet published an advertisement. The cover's words appeared to be quoted from candidate Abdullah Gül. Mr. Gül alleged the sentences falsely published at English newspaper Guardian and used by Cumhuriyet to defame him and brought a civil action for compensation against the applicants before the Ankara Civil Court of First Instance. Without listening to applicants and depending on documents that claimant provided, court ordered an injunction. The court decided that Article 10 of the Convention was breached. Okay, here we have come to the end. Thank you for listening.